evidence here where Mrs. Rupneet Sidhu, who's no longer with the agency, she sends him all the information that he requests, and it's noted in the log. That's really strange. Here's another email from myself to Letitia Daly, copied to Matt White. Thanks for speaking with me today on the status of the Garcia-Hoven investigation. I understand that there are no impediments holding back the Garcia-Hoven ID. That's not in here. And there's another email. Here's from me again to Letitia Daly, investigator. Here's our position response on May 15th. Well, that's in here. So the only difference I can see, Judge, is that between the time when the policy is being followed and the time the policy isn't followed, there's this letter here from you that's put into this investigator, put in the file, that says that you have ethical concerns, but it also really says that you don't know the difference between what the law is on whether two parties are adverse and whether two employees can be adverse to each other. And let's recall that we then also had a motion by these gentlemen over here to remove me from the case based on your opinion. Well, you also then had an opportunity to figure out what the law was there. That's when we put that in front of you at that point. You didn't rule on that decision at all. You made no response on the core issue of that claim whatsoever. Namely, can two employees be adverse to each other in the Equal Rights Division? Now, you've got that on paper, Judge, and you've been told what the right answer is by several people. And again, an independent body reviewed this. It took them less than 24 hours to figure out what the correct response is. But you still haven't taken that letter out of the file. And still, again, at the moment that letter goes in the file, then there's a different set of policies and procedures that are being followed for this case, aren't there? And that really then is the problem. So we now are moving for a consolidation of these two cases. You told us before that you would consider this when and if this happened. Again, I find it very significant that we were not able to get this, that we didn't get this ID except by snail mail the moment that we were supposed to have ended our case. So here that we haven't ended our case, and the number one priority in front of this tribunal now, as is clear, is having Dr. Garcia-Hoven end his case. And I assume that these two things are connected. Because again, propinquity says a lot. And it didn't just happen that this document came by snail mail, because Letitia Daly's practice is to email. I know that because I've had that happen several times. I checked with my colleagues. That's how she does it with them. But just one case here, something's different for it. Something's different. And I think we've all placed our finger exactly on what that thing is. Now, again, this isn't just a probable cause determination. It's the most damning probable cause determination that I've ever seen. There is no doubt in this investigator's mind that they have discriminated against him and continue to harass, bully, and torture this, not just Dr. Ford, but also Dr. Garcia-Hoven. And that, I think, is really all that we, and look at this. I mean, I think I see the name Dr. Ford in this probable cause determination more times than I see the name Dr. Garcia-Hoven. And I think it's clear that, and as we have identified, that there's a clear line from Dr. Saffold, who's pitting them there, to Dr. Holliday. That's the through line through all of this. But let's recall now that this tribunal has bent over literally backwards to remove Dr. Holliday from this case. And it's significant because, again, snail mail. Not until we were supposed to have rested our case did this second come out. So, again, this brings us all back to the question of common sense versus the law. There appears to be a secret policy at play here that is prejudicing plaintiffs. There seems to be a secret common sense that hasn't been divulged to everybody else. Possibly we'll call it uncommon sense. That's not published in the law. There are secret rules here that apparently are designed to keep employees, and this is what's spectacular here. Because this letter of Dr. Garcia-Hoven, this is your July 29th letter, Judge, is expressly designed to try to keep Dr. Ford and Dr. Garcia-Hoven from working together. That's the message loud and clear. Confidential. You, Ben Hitchcock Cross, are not to share facts from Dr. Ford's case and Dr. Garcia-Hoven's case. That's what it says. You're concerned about confidentiality. Because of my concerns of confidentiality, now it's I reviewed the Supreme Court rules. Well, again, you were quite clear in that letter that it was very possible for Garcia-Hoven and Ford to work together if they wanted to. But yet you threatened us, and this is a threat. There's just no doubt about it. It was a threat. It was intended to be read by outside sources, which it was. It was the message here was to more than just to attorney Ben Hitchcock Cross. It was intended for a much wider audience, and it got apparently viewed by at least Milwaukee Public Schools' Chris Reardon, who again copied it nearly verbatim and filed a motion to have me removed from the case. Which, of course, you didn't respond on the merits of it because I couldn't tell you why. But it's baffling to me, Judge. So, then we look again at the influence on the investigator, which we specifically raised and brought to your attention, that this letter, besides being legally incorrect, was prejudicial to Dr. Ford and Dr. Garcia-Hoven's other cases. And I think we can just examine why. All you have to do is look at the case log. It's so prejudicial that emails and direct conversations, calls with the investigator and Matt White are not even put on this log. And we told you this would happen, and you declined to remove this document from the record. Well, that's problematic. It's also evidence of more bias. So we're back again where we were yesterday, except now we've got more evidence of why you should not be on this case, because again, you made decisions before the fact. You've got this letter out there that says you've influenced the other case, you've influenced Dr. Ford's case, prejudiced them, and you've got this letter out there that you refuse to retract that's legally incorrect.
Although I stand by the letter, you had raised a motion to consolidate. Do you have any response to this motion to consolidate?
I do, but I think we need to address the issues that are actually before first. I don't know if you want to do that or not.
Well, why don't you just, he started with the motion to consolidate. If you want to say anything about his motion, go ahead.
I think the motion to consolidate is untimely and relevant at this point in time. With regard to this particular hearing, we've had numerous depositions. We're in the 5th day of the hearing. They have delayed putting on their last witness in order to make this motion consolidate. If we were to consolidate, we have to start this all over. The amount of time, money, and just manpower that would be expended to recreate what we've done here today, as well as defend against this new allegation, is just immense and impossible. I think consolidation occurs if you have to continue the case. So you don't waste judicial effort, you don't waste time, and money. The issues are all set with regard to this particular case. We're at the end, and again, as I indicated, Attorney Chatros is delaying presentation of his last witness to move to consolidate. I talked to Attorney Chatros on May 23rd, 2003, in which I sent a letter to him to memorialize this conversation. He said we had one witness left. Garcia Holt, he would be done, and I needed to present my case at 1 o'clock. At that time, Dr. Garcia Holt had not tested positive for COVID. Attorney Chatros indicated yesterday that he knew he was in Columbia since May 23rd. And he made no arrangements to put Dr. Garcia Holden on WebEx or Zoom in order to present his testimony. He should have arranged that testimony. He did not. You, in fact, ordered Mr. Chatros, or Attorney Chatros, to one, provide us with the test results by 5, which he did not. To provide information regarding Garcia Holden's return flight by 5 o'clock, which he did not. And to inform us whether Dr. Garcia Holden was available for testimony by 5 o'clock last night, which he did not. In fact, when you asked him today, he didn't even address the issue of whether he's available to testify. He has delayed this in order to make this motion resolved. I think it's inappropriate. I think it's irrelevant. And I think what the court needs to do is strike Dr. Garcia Holden as a witness at this point in time and close their case. At that point in time, consolidation is not relevant. This delay, there is no excuse for the delay to put Dr. Garcia Holden on. He knew on May 23rd, and I will provide you with my copy of my letter that I sent to him memorializing this conversation.
You said May 23rd?
Maybe it's March 23rd, I'm sorry, March 23rd.
Sweet.
Indicating that this was his sole witness. At that time, Dr. Garcia Holden had not tested positive for COVID. And Attorney Chatros knew he was in Columbia, as he indicated yesterday on numerous occasions. In fact, we provided information that Dr. Garcia Holden is not going to return to this country until April. This is just a delay tactic to make this motion consolidate. And first of all, I would strike all of the argument that Attorney Chatros just made, because it's irrelevant to this case. In fact, it's argumentative and it's demeaning. So, as I said before, he is appearing here on behalf of Dr. Garcia Holden. He is not producing as a witness or made arrangements to produce him for a witness, nor did he ever intend to produce him as a witness, as you can tell from my letter. He knew he was the only witness. He knew he was in Columbia. Did make arrangements to have him appear by video before he testing positive before the weekend. This is just a delay tactic to get this motion to consolidate. And again, as I said before, with regard to a motion to consolidate, it's too late in the game. It costs too much money, waste judicial time. It defeats judicial autonomy. To restart this case would just be immensely expensive as well as time-consuming and just a judicial mess. So I would oppose the motion, and besides that, I think he's got to formally file a motion to consolidate and allow us time to file a written response, which he has not done. I've never seen a motion to consolidate in this case.
Oh, yeah. I'm gonna get all this on the record, awesome. Thank you. Damn. So that's.
Wait, is this all one?
Yeah.
Okay.
All right, appreciate that. So
Excuse me
he.
before we...
No, I'm
No,
speaking here.
excuse me.
I'm speaking here.
Excuse me.
I'm not going to excuse you, that's why I'm saying I'm speaking
You
here.
guys need to stop. Your professionalism is atrocious. I mean, throwing documents at people, throwing them at the court reporter, sliding them on the table. I don't care how upset you are about decisions I've made. I expect attorneys, particularly attorneys who have appeared before us for years, to act with some professionalism.
I would just ask the court clerk to actually mark the keys.
I can mark them.
And I would also obviously object to the admission of exhibits.
Okay.
But I'd ask this court whether we need to break.
Do you want to take a break while you work? Go ahead.
Okay.